All right, welcome everybody to the AI Meetup. I'm Tim May, I host. And we're going to have a great speaker today. Joshua Stacy is going to take us through how to crack the spine of legal inequity, and believe it or not, that has something to do with AI. Anyway, if you don't know, I have a meetup.com for the AI Tech Alley Meetup. If you sign up, if you're not already there, I send you ahead of time what we're going to be talking about each time at Tech Alley and some other information. So feel free to sign up. With that, I'm going to turn it over to Josh. We're going to have a mic, so if you have a question, sort of wave your arm. I'll bring the mic over so that we can actually get your question on the video, which we're doing. And as for folks who don't know, we actually have a whole channel, Tech Alley does, and that all of the AI meetups we've done over the last few years are on that channel. All right, with that, I'll turn it over to Josh.
All right, one last housekeeping thing on the microphone. If you don't have that mic or this mic, it won't go on YouTube. And it's very hard for people on YouTube to actually hear anything. So I'll make a song if you're raising your hand and there's no mic. It's just for that. So with that, I will pat myself on the back a little bit. The AI videos before, this is my third time here, and my videos usually pull pretty well. The only person that does better than me is Matt Renzi, and he's working on a doctorate at Johns Hopkins, so I'll let him take the win on that one. So for today, I'm going to talk about cracking the spine of the legal industry, because I don't like it very much. And, well, AI has really changed the equation quite a bit. I have personal experiences I'm happy to talk about. Certainly going to have time for questions at the end here. For those that don't know, I also talk massive amounts of shit on LinkedIn. If you have questions for me and would like to talk to me on LinkedIn, everybody's always welcome. There's the QR code. I will show it again at the end. As one other sort of point on that, I'm frequently arguing with attorneys and judges on there as well, and that's fun, and so God bless America. So with that, about me, over 25 years of computer engineering experience. I don't remember how that all happened because it seemed like that number should be smaller, but in 1998 I was working on things, and I've been doing that sort of ever since. I have experience as a pro se litigant. If you don't know what that means, that's when you're litigating and you don't have an attorney. It's just you bare knuckle with the court and everything else that's going on. I'm not an attorney. I did run to be a lawmaker, and I got 28% of the vote in the primary. So if things had gone just a little bit different, I could have been one of the people actually working on writing the law. And I bring that up because a part of what's so exciting about our government here is it's actually we the people that we talk about. The people vote for the lawmakers. We vote for the judges. And if there's a trial and a jury sees something and they say that the law doesn't make sense, the jury can say no. It's called jury nullification. They can say that's not at all what we meant. So the focus of our legal system has drifted towards attorneys and legal professionals and away from the people. And I think that's sort of the thesis that we're going to be running at today, is that language models have really been a seismic shift in that landscape. And I'm an angry dad, and we'll get to that a little later. So why does AI and legal matter? That's a great question, I thought. That's why I put it there. So the original vision, our founders believed that equality under the law was possible. That's exciting. And they thought it was literally worth going to war over. And they won. And that's pretty cool. That's pretty cool. So the reality is today's legal system makes equality under the law nearly impossible. We've got lots of barriers. So let's talk about some of the barriers. A lot of times in the courts, they have systems and procedures that make sense. There's legal doctrines they use Latin terms for, like res judicata or collateral estoppel, or lots of other. Then there's the Colorado River doctrine and the Rooker-Feldman doctrine. Raise your hands if you know what all of those are. I'm seeing one or two liars, and everyone else is keeping their hands down. So part of what my experience with language models has been is, if we roll the clock back 2 or 3 years, roll back to when ChatGPT 3.5 was out and Turbo was just about to come out. The total context window, meaning the amount of information it could sort of digest in a chunk, was relatively small. So you could come down and be like, I don't understand this thing. And it would give you sort of like a better answer than none, but still not great. A lot of folks have been dogging on ChatGPT 5 because they're haters. That's my only thought on that one. It can do expansive readings. I've fed Grok and ChatGPT both like 200-page transcripts, and they can read through and find, like, read between the lines, here's what the person said, here's what they really meant, all of this other stuff, and I'm like, wow, this is cool. So language models really crack the universe here in the sense of they're able to connect directly with you, right? So let's, as a starting point, let's say you're having a conversation with a language model. Language model's like, hi Jerry, how you doing? And you're like, oh, pretty good. And if you let it know sort of your frames of reference, it can really meet you where you're at and explain it to you in ways that make sense. You can ask questions back and forth on it. So if you get a document and you're like, I don't know what Rooker-Feldman is. I don't know what collateral estoppel is. What is this res judicata? Well, now you can know. So let's talk about some examples of where this might be really useful. Got a prenup. Raise your hand if you know someone that wishes they had had a prenup. Okay, so you found your person, you're in love, oh, we're gonna have this holy union, but just in case things don't work out, and you don't wanna hate each other forever, it'd be nice to have that, okay. Litigation, someone has trampled your rights and you wanna get your day in court, or someone's suing you and you don't know what to do. Discovery, now, discovery is a pretty basic concept in law. Raise your hand if you know what discovery is. Okay, about half the room. For those that don't know, discovery is basically when you're exchanging documents with each other before you get ready to go to a trial. So this is when they say, I need these documents, they send out a subpoena, I need this, I need that. And business law, you're like, oh, I've got this really great idea, but I don't know if it's legal. One of the products I've been working on is a cannabis product. And it's kind of funny because in the state, it's actually legal. And I found all sorts of nuances about the laws about how much THC you can put in something, what the labeling requirements are, and all this stuff without having to do lots of research, not having to attend the Nevada Cannabis Council Board, whatever the CCB is, and reading through everything. And I was just like, hey, I want to do this thing. And, okay, cool. So before an LLM, if you want a prenup, you're going to have to talk to an attorney. It's going to be maybe $3,000 to $5,000. They're going to charge $200 to $500 an hour. Now, might you be able to find a discount lawyer? Maybe. I wouldn't trust an attorney that charges less than $100 an hour. So, yeah, all right. So we've got that. A lot of times the forms, if you kind of go to Rocket Lawyer, or yeah, I think Rocket Lawyer or any of these legal forms, they're still going to have language that you might not actually understand. And that's not super great. It can take weeks to draft and finalize, going back and forth between attorneys. We live in a town that's famous for how quickly you can get married. So why spend 3 weeks working back and forth on it? We can do it now. So at $3,000 to $5,000 each, it's basically unreachable for most Americans. So the result is a thriving law industry that works on settling disputes based off of shifting laws. For those unfamiliar, if you do decide you're going to have a divorce, the laws that you will be bound by are whatever state you're living in at the time and whatever laws are at the time, not necessarily the laws when you got married under. So if you don't have some foundation where you say, all right, Jerry and I are going to join in holy matrimony or unholy matrimony, then what's going to end up happening is you're going to be defaulting to whatever the laws of the state are and under those rules, which basically it's two parties agreeing to an agreement that can change over time and neither party has control over. So, does that all sound pretty good? Yeah. All right. Well, so let's talk in a post-LLM environment. You can actually draft agreements in plain language. Make sure you and your loved one are agreeing on the same things. And you can go back and forth on it, and that's nice. You can spend a lot of time really trying to understand the terms. If you're paying $250 an hour for an attorney, you probably don't want them to really take the time going over everything, even though really going over everything is probably really important. Language models can read through contracts really easy, really quickly, and spot different types of issues, maybe things you weren't even thinking of. As a good example of why you might want to use something like this is, well, what if you and your partner agree, oh, we like this thing, and you put it in there, and it's like, oh, actually, what this means is quite something else. Oh, okay, well, that's not great. Now, I don't like attorneys as people or as a profession. Now, I have some friends that are attorneys, and I don't hold that against them. However, the fact of the matter is attorneys do provide some value, and even in a post-LLM environment, if you go to an attorney and you say, here is what we have come up with, you're going to save a bunch of money because they're reviewing a document, not drafting a document. Also, you'll be able to better understand it, so even if we're still working with attorneys, it's a better way to work with the attorneys because you're starting at zero. Or you can skip the lawyer altogether. So we've got that going on. Now, let's talk litigation. Has anybody ever been in a lawsuit as a defendant or as a plaintiff? Yeah, it's not fun. Don't recommend it. So before language models were out there, you really need an attorney to even know where you were starting at with it. So lawsuit typically starts with a complaint. Someone says, I hate this person because, here's my grievances, and then you have to look at that, and then it says things like, you need to file an answer, and you might think you know what that means, like answering a question, but actually there's a lot more to it than that. Researching case law can take days or weeks. Also requires expensive tools, like LexisNexis or FindLaw, or any number of other legal research tools that might not even be available to consumers. There's procedural traps. There's a lot of for example, if you don't respond in time, you can have a default issued against you, and you might have a legitimate reason for why you haven't responded, but the road is fraught with danger. And that's all not great. In a post-language model environment, you can draft a complaint or answer with plain language guidance. So sometimes part of the game with litigation is making sure what you're saying is confusing and evasive. And with language models, you're able to take whatever document you've been served, if someone served you with a complaint, you can actually have the language model parse through it and go over what it's actually saying and what it's meaning. And at a deeper level, it can even say, well, here's what they're saying, and here's what they're sort of reading between the lines, here's what they're trying to get to. So that way, when you file the answer, you can be mindful of the traps that they're setting up for you. Now, is this 100%? No. Is it a massive improvement over where things were before? Absolutely. In my campaign, I had a disagreement with my opponent. I filed a lawsuit against her. And we settled, and that was really nice. And her attorney said something that was very flattering. He said I was the most capable pro se party he had ever dealt with. And I was like, thanks, ChatGPT. We fucking did it. We did it. It can also pull relevant statutes, case law, and precedent in minutes. Now, within law, a lot of times there is conflict or there's gray area. There's parts of it that might seem like they make sense, but then when you actually look at the case law, it goes in another direction. Part of what I've learned by being as involved with doing legal research is a lot of times, so for example, at a very high level, we've got the Supreme Court of the United States of America. Okay, great. Most people will never end up there on anything. Right below that, we have circuit courts, and those are appellate courts for if a district court, which is the federal court makes a decision you don't like, you can go to the appellate court. Within each circuit, any decision an appellate court makes is binding on that area, but not on the whole country. If the Supreme Court makes a ruling, it's binding on every court in the country because that is the highest court in the land. So one of the things that's been really interesting for me lately, the way I've been using it, is we've got situations where circuit courts actually have different opinions. So it might be the 10th Circuit looks at one doctrine one way, but the 2nd Circuit looks at it in another way, and you're litigating in the 4th Circuit. A lot of times where things will end up at the Supreme Court is when the circuit courts have disagreements, they're split decisions. And so the Supreme Court will go, okay, well, we need to listen to this. The Supreme Court only listens to cases they choose. Must be nice. Reserve the right to refuse service, okay. They hear like 1% of cases that get requested, and usually what they're doing is trying to bring coherence to the circuit court system. And so this way we're getting, at the end of the day, surprisingly enough, we're actually trying to just get consistent treatment in the courts. That's the whole premise of the legal system. And so if we have one circuit going left, the other circuit going right, the other circuit going up, the other one going down, that doesn't create legal stability, which makes it hard for people to live their lives or businesses to operate. So what's interesting is At the state court level and below, or like lower courts, there's a ton of courts and a lot of the data isn't available. Once you get to a federal court, there's a lot more data that's publicly available, so the models are getting trained on. You go to the appellate level, it's very, very accessible, and if you get Supreme Court rulings, they're super public and there's lots of resources on that. So it's not just, hey, I'm upset about my neighbor. You can actually say, hey, I'm upset about my neighbor. What circuit am I in? And how have they ruled on this before? And like spot trends on things. And so the fact of the matter is it's not even just about understanding the law or what your rights are, but how are the courts actually going to rule on this? What have they actually been doing? You can also map deadlines and procedural steps automatically. So one of the cases that I'm involved in right now, I was expecting to lose at the federal court level and expecting to have to set the appeal. Now, for those that don't know, which is probably everyone, and that's fine. At the appellate level, you can only argue based off of what you've argued at the lower court, and you have to say they got the decision wrong because they violated some actual law, not just I disagree with them. It's not an appellate decision. So what you can do is, if you're sitting down and brainstorming it ahead of time, you can bake into the record all of the arguments you might want to bring up later, so that way when you're at the appeal level, you've actually got the details there. And if all of that sounds confusing, you can sit down with the language model and talk to it forever for a couple of bucks. And so this is why I say it's helping invite legal equity, because you can actually sit down and talk to it and look at the right references and all that other good stuff. And like I said too, right, you can research. So Rooker-Feldman is a doctrine that basically says, it was made famous in 2005 with this case, Exxon versus Saudi Basic Corp, something like that. Ruth Bader Ginsburg, she made some rulings on that, and it basically said, here's a four-pronged test. And what this is about is, if you have, let's say you go to a state court, and you have a problem, and you don't like the ruling, you need to go through the state's appeal process, not go to the federal court and say they got it wrong. And Rooker-Feldman essentially says, state courts are where state issues get resolved, and we don't touch it. Now, Rooker-Feldman is a doctrine that's been applied differently across the different circuits. And so you can say, instead of just saying, oh, I have this particular doctrine that's involved in my case, and what's the law? What is it that is meant? You can say, what are the trends, and how are judges looking at this, and really isolate the nuance of the arguments that you're making. An attorney's not going to go through that with you. Okay, so discovery, in a pre-LLM world, discovery, a lot of times there's a term called a document dump. So you say, oh, I want the financial records. And so they give you 9 boxes and say, have fun. You're like, well, that's a lot to go through. Well, now you can, well, we'll get to now, so that's a problem. But going through thousands of pages, reading them manually, that takes time. Now with electronic discovery, it's a little bit better, but you're still having to go through a lot of pages and read through a lot of stuff, and it's like looking for a needle in a haystack. Because of that, important evidence, things that you care about, things that you find are interesting, that might be lost in the sauce. And organizing these for the court, because even once you find the thing, you then have to go to the court and very cleanly and concisely say, and here's why they are wrong, or here's why they did the thing, or whatever. Post-LLM, you can sort and tag a lot of stuff. So for example, you could have a model go through and read a document and say, here's roughly what this is, and catalog everything, so it's easier to go through. You can also say, I'm looking for this specific issue. And I'll just say as a general note with language models, if you said, for example, the prompt was, here's my complaint and find things that will help me with my complaint, it doesn't give it as much focus. And so if you said, I'm looking for instances where they were inconsistent on this point, or something like that, it does pretty well with very focused requests. So you can flag key phrases and contradictions, right? I'm looking specifically for this thing. I thought that this guy would go to Henderson on Thursdays, find me every transaction that was on his bank statements on Thursdays in Henderson. Okay, it's pretty good at that. Right, and the better you organize your information in discovery, the easier it is to either try to settle or to win in court. A lot of times courts reward clarity and brevity. You know, they've got a lot of court cases that they're going through, and so the easier you can make it for them, the better. Now this last part I love. So depositions, we know what a deposition is. You sit down, you go ask the guy a bunch of questions. One of the things that's really interesting is because language models are, again, language models, they've learned a lot about human subtext. So if we're saying one thing, it means we're not saying other things. There's ways that people are evasive about things. It can read between the lines better than anything that I've ever seen, because it also understands more people than any humans ever understood people. So it's not just it's better at doing the things that are currently done, it's also able to help you really uncover insights that you wouldn't have otherwise. One of the things I've enjoyed is if I get a brief from the other side on something, I like feeding it to the language model and saying, what are they really thinking? And then they're like, I get insights. Now, this is Tech Alley. We got lots of startup ideas going on. Raise your hand if you've had a startup idea and you're like, I don't know if it's legal or not, or how to do the licensing on it, or some maybe not, is it illegal, right? Most of you probably don't want to start hitmen services, for example. But just to understand the basic licensing and compliance requirements, a lot of times that involves people say, go talk to an attorney. You can get your starting research done if you say, I want to sell bread on my porch. Can I get, what do I need? It might point you to the cottage license. You can say in this area. Over the last year or so, language models have been a lot more, I would say, engaged with going to the internet looking for answers. So like if you're like, I'm in Clark County and I want to sell eggs on my porch. It could go to Clark County and look for everything there and give you at least an initial run at it very effectively, very quickly, and that's pretty cool. The other thing is sometimes you'll find outdated information, and it can go through and sort of look for conflicts between state and federal regulation, a lot of stuff like that. And then, all right, so the pre-LLM world, it takes time, all this other stuff. Post-LLM, it can give you a plain checklist of the things that you're looking for. Now, I don't like the government, partially because, well, it's awful. But on top of that, I was a Medicare Advantage agent, and then Congress passed a law that made marketing Medicare Advantage effectively illegal. I'm painting with broad strokes on that. And so I typically try to avoid any industry that's regulated. So if you're taking a look at a business venture and you're like, look, I want to avoid having to deal with unnecessary regulation and overhead, one of the things you can do is brainstorm with the language model and say, oh, I like this, but I don't want to have to deal with this licensing requirement. What is something similar I could do, or something like that? And it can help you actually navigate and brainstorm it. Attorneys are generally not inclined to do that. They're going to say no across the board because that's the safest decision, is to not advise for things that might be problematic. Right, so it can summarize and interpret relevant laws and exceptions/loopholes. I don't know, loophole makes it sound like you're trying to do something bad, but there's exceptions. Exception's a nice, polite word. Can also draft your foundational arguments. A lot of times, people, when they're getting started a new venture, they want to have terms that everybody's agreeable with, but maybe you don't have the right language for that. And so you can brainstorm back and forth on that with the language model helping provide guidance and insight across the board about all sorts of different things. Brainstorm other ideas. All right, so who's ready for the family law deep dive? Okay, so I came up with this definition. Family law is the industrialized exploitation of human suffering. Oh, I'm hearing some laughs. That's hitting. Oh boy, we're getting the two. Yeah, no, it's, so I'm not going to limit the cost to men, but I am going to point this out. Family courts often strip fathers out of their parenting time, which isn't good for the children. We'll get to that in a sec. Financial burdens are imposed without regard for whether or not they can actually pay, and in fact, disregard for actual inability to pay. Isolation and hopelessness are common outcomes, not the exception. And men are 9 times more likely after a divorce to take their own lives, probably on account of the isolation and depression and not seeing their kids. Kids these days. All right. But it's also really damaging to children. Children have whiplash between going between households. Court-ordered arrangements often ignore the children's needs, including their need to have a father in their life. High conflict causes harm for children's mental health, not just for years, but for their lifetime. These are significant problems. There's incentives to lie in the family law industry. It's a system that rewards dishonesty. I heard a family law attorney once say in law school they were trained to make any argument that they thought they could make with a straight face. And so that's the level of aggression you're dealing with on these things. False allegations do shift custody and increase payouts. And kids become bargaining chips for more control and more money. So attorneys help make all of this possible. So on a more personal note, I used LLMs to understand exactly how I was getting screwed by the court. So sometimes you know you're getting screwed, but you don't know exactly what they're doing wrong. So I used LLMs to read through the briefs. I said, here's what they're saying. This doesn't make any sense to me. Help me make this make sense. And I found similar cases. In fact, there's one situation where there was a judge in West Virginia that lost judicial immunity, which is nearly impossible. And it was in the Fourth Circuit, which is where my case is. It wasn't that nice for me. Thanks for helping me find that language models. So I identified the specific laws and rights. So a lot of times, folks when they're pro se, they'll say, Your Honor, the judge just got it wrong. And as interesting as that may or may not be, the court can't really do anything with that. They need to say things like they violated Virginia subsection 20-108, which of course everyone in this room is very familiar with because we're in Vegas and family law is well known. There are interesting features of this law. One of the things I learned is that the court itself did have standing to do some things. However, they still needed to invoke it, which they never did. So I knew I was getting screwed, but I didn't know how I was getting screwed. And I was able to sit there and talk to the robots for long enough to start making sense of it and really try to become the expert on it. So then I used LLMs to go on the offensive. I had it review my fact patterns to say, okay, what are my best venues for relief? Do I go to a state court? Do I file a complaint? Do I file a motion, a petition? Do I do this? Do I do that? Do I do whatever I do? Then I went over all of the evidence. I looked at the transcripts, I looked at this, and I said, what insights can you draw from this? And it actually pointed out some things that made no sense to me until it explained them because I'm not an attorney and I didn't know these things. They're like, oh yeah, when they did this part, it was completely wrong. It didn't follow procedure. I'm like, oh, that's helpful to know. And then I drafted a complaint, and then I filed a complaint. But before I filed the complaint, I said, okay, before I file this, what are they gonna say and how are they gonna try to defend against it? Then I rewrote it a bit to reincorporate that. And I was able to game it out and really think ahead. And I was able to do all of this before they even knew I was making a move. Thanks, robots. All right, so we've talked about how language models have changed the landscape. And I've talked about how I've used LLMs. But now let's discuss what can LLMs do for you? So, if you thought I did a good job, now would be a good time to clap. Thank you, thank you, thank you. So the next slide is, so we can either talk about LLMs in law or you can ask me anything about AI. A lot of times we have a lot of good discussion here.
How's it going? Yeah, beautiful presentation. I think it makes definitely a lot of sense too with law versus regulation. Like if you're writing policy for a company, you know, how can I write this law and then put it in the system? How would OSHA find me on this? And then rewrite different parts. So I could definitely see the applicability. But how would a business owner combat the issue of putting their policy into a large language model, which we're told not to do, to then analyze it, to rewrite it, to make it a better policy?
All right, so that's an excellent question, and I'm going to expand it out a bit to cover a few more things too. So if I understand correctly, a part of what you're saying is, you know, we're told not to put information into these language models because if we're talking about legal things, we lose our confidentiality, privacy, those types of things. I'm getting a nod, so I'm assuming that's a yes. So a few things. One, if you're talking to the language model in generalities, unless they subpoena it, they're never going to see that most likely. Now that's not enough to get us across the finish line. The other thing is, I've seen a lot of fear porn on LinkedIn about AI and using it. And I would reasonably expect if I had invested years and hundreds of thousands of dollars in becoming an attorney, I wouldn't want the robots taking that away from me. That's fair. Attorneys will sometimes say that, well, if you talk to me, you have attorney-client privilege. Well, there's also a confidentiality in terms of if you're working on your own product, working on your, let's say you're involved in litigation or think about litigation, and you're working on your documents, your briefs, that's protected under, it's essentially the individual version of attorney-client work product, but it's litigation work product. So you've got some confidentiality on that. For example, they can't just subpoena your Google Docs or your, give me a copy of everything in your hard drive. So I would say in general, let's just assume none of that protects you. Make sure when you're talking to the language model, you're asking questions in ways that doesn't look incriminating. Incriminatory is the word I wanted to use. I think my brain's not making, that's not a word. But a part of it is, if you're doing research ahead of the policy, right, there's nothing wrong with acknowledging saying, all right, we've got this policy and I have these concerns, what are your thoughts? And I'd make it very brainstormy. So if somebody was reading through it, they would be like, the guy was just looking and doing some research on it. So does that provide insight or did I wander too far?
Somewhat. The only issue was just in that original corporate structure. I mean, like in policy, they say if you do this, you will be terminated. Like that's the issue. Is that, like you just said, they're not incentivized using their company policy and putting it into a large language model. Because what you just said about LinkedIn, with the fear porn, if you do that, the whole world now has your policy. And the company doesn't.
Oh.
So as much as the tool can sharpen the policy, you're legally, quote unquote, not allowed to do it. So,
Okay, well, so I'll add one other piece to my answer. And this is a better broad picture AI discussion. The amount of raw compute it takes to run like ChatGPT or Grok or any of these big models is enormous. Part of the reason why I use APIs with OpenAI is because I don't have $500,000 for graphics cards. The cost for compute, within the last 2 weeks, OpenAI released one of their models that you can run locally. So if you wanted to be the belt and suspenders covered all the way, if you ran it locally on your own hardware, you wouldn't have to worry about it leaving the office, so to speak. So I'd say on anything like that, you might actually want to run it locally.
To add to that.
Mike.
Mike, yes, well, I'm giving to yours, whatever. If you have a task, like a 100-page document, you can run it locally just on your CPU without a GPU. It'll just run really slow, but it's running while you're asleep. So some of these things that are really large contexts where there's a lot of crunching, you can run one of the larger models if you have enough CPU memory. You just have to wait longer, even if it's 7 tokens per second coming back. So you don't even need an expensive GPU for some of these models running locally if you can wait long enough for the reads.
Well, and I think, just to put a fine point on that, we're transitioning now to the point where a lot of stuff's going to be running on device. We're seeing more and more stuff is going to be running on your device in your hand even.
Everything that you said technically is close. I used to do federal mediation. If a contract is involved, it's a whole different ballgame, because I've actually had to argue government contracts, through federal mediation. So it's a little different than
Contract law.
contract. Yes, it basically is what it is, contract law. Because no matter if it's right or wrong, it's basically stated in the contract. And in that, saying that, it's still a statewide thing, because if you're in Detroit and I'm mediating your case, now you're going to complain about snow and not having the ability to clear the snow out. But if you're in California, it wouldn't be relevant. So you kind of have to know the contract before you can actually debate.
Well, I'll speak to that. One of the unique things about our legal system is you can enter into private contracts. That's what a prenup is. And the contract, right, if there's Chris in the back, if him and I agree to do something and we write a contract and we agree this is what we're agreeing to, that is going to supersede generally every piece of law. So that's why we would feed it into a contract, and then you're limiting it to the contract. All right.
Hi, Chris, engineer. Use a lot of the different LLMs. I'm curious in terms of the law, which one you found hallucinates the least?
Hallucinates the least.
Right, so they're each different, right? So it's, I think you're using a broad context, say LLMs, but each one of them, I think, have better pros and cons of different results that they hallucinate. Which one do you find in terms of the law hallucinates the least?
Yeah, I'll give an expanded answer to that. So hallucination is when you're like, give me a case that says I'm right. And then the language model goes, here you go. And it says so-and-so v. so-and-so, but it's completely made up. And there's been a lot of instances of, usually the fine's anywhere between $1,000 and $3,000. I saw a sanction issued. So if you piss off a judge, which I don't recommend. One of the best ways to piss off a judge is to lie to them. Making up law is a really great way to do that. One attorney got sanctioned, and a part of the sanction was saying that every time they're in any case, they have to show this order to the judge hearing it. So now they have to tell on themselves in every future litigation or risk. So that's hallucinations. So what I have found is when it comes to researching case law, I never trust it, and I will always review every citation before I submit it in a pleading. For those that aren't familiar, there's this federal rule of civil procedure, Rule 11, that says you have to attest that everything you're saying is true under penalty of the judge sanctioning you. And so what I would say is, to answer your question directly, I think Grok with a K is generally better at the citations. My general workflow is OpenAI is usually better about sort of dissecting the argument. I call Grok lovingly the institutional apologist. So it tends to take the side of the man, which is really great if you're going to be arguing against the institution. So now you can test your arguments and win it out. So like in one thing I was working on, Grok started off thinking I had about a 10% win chance, and I got it up to about 50, 60%, which for that is basically pop the champagne. It's a guaranteed done deal. ChatGPT, of course, right off the bat, it's like, I'm rooting for you, buddy. You got this. And I'm like, so I'll go, be blunt with me. I'm like, this is a serious thing for me. You can hurt my feelings. I don't care. I want to win, or I want to know why I shouldn't try the fight, because it is enormously resource intensive to engage in litigation. I've spent so much time now, I'm a better writer because of it. I believe it's helped with my organizational skills. I think a lot of my engineering background makes it easier for me to digest and dissect and break everything apart. Grok is, but again, to reinforce, Grok is generally better at finding a case. It's also better at if you have a document and you want to make citations within it, where you say, per paragraph 3 or section 3, paragraph 2, all of those citations, Grok's really good at it. And I love ChatGPT to pieces. It's my favorite of all of them, but that's not its strong suit.
You're using those two as your primary Grok and ChatGPT?
Yeah, just for the YouTube video, the question is, am I using primarily those two? And the answer is yes. When I first started working with language models, I said, I'm going to get really good with one of them. And I happened to pick OpenAI and sort of run with that one. So that's my benchmark. That's where I sort of start off. And then Grok also has limited ability to think across sort of the whole context. At this point, I've been using ChatGPT for like 3 years. So it knows all sorts of things about me in all sorts of detail. And so it can tell sort of my inclination stuff. Grok, most of the time, every time I start with it, it's roughly a clean slate. So usually what I'll do is I'll brainstorm everything in ChatGPT, and I'll go, hey, Grok, can you check? And I also find having them check the citations against each other. So if ChatGPT is like, here's the cases, I'll be like, hey, Grok, is this right? And the other thing is, because they are going to the web a lot, you can have them actually do citations, especially with any federal cases. Usually those are publicly available. And so I would always read the fucking case.
Yeah, I just wanted to touch on the confidentiality is pretty important. When you guys are asking questions, legal type questions to an LLM, all of that is discoverable. So your questions,
I don't know that that's true.
Current precedent is it is. There's sort of
I want to see a citation on that.
There's talks about whether or not there should be confidentiality. You touched on if there's business secrets in the conversation, you can make arguments to cast aside that evidence. But currently, all of it is discoverable. So in the way that you are phrasing your questions to the LLM, act as if you're on the record. Because current precedent is they can't.
Where?
Until they make a law.
Citation.
Well, we just had a recent judgment. I can share with you, Sam Altman
Sam Altman's full of shit, though. He's not.
He had an in-depth conversation about this.
He can't even make the fucking decision.
Josh.
I argued this
Josh,
on LinkedIn with attorneys.
Whether or not, okay, you're arguing whether or not it should be that way.
No, I'm talking about the law,
we need to argue about whether or not what is. Current precedent is that judges subpoenaed OpenAI and said that they have to save all, even if you delete it from your conversation, OpenAI is required to save all those currently.
Doesn't mean it's discoverable.
Until the law changes, they're currently required to. So
No, they're required to save it, but
so
they're not required to
run
disclose it.
The key here is that as everything stands right now, run locally and talk as if you're on the record because you currently are. That's it.
Well, and I'll touch on that because Chris does raise an excellent point. He's wrong on one point, I'm convinced. But he, there was a federal judge that made a crazy decision that I believe set us back in innovation, and it delayed, I believe, the release of ChatGPT 5 because it required OpenAI to store every conversation, even if they said they'd delete it. The delineation, so I agree with Chris on that 100%. The delineation is, the requirement is that they store it. I haven't seen anything that says they've had to produce it in discovery. And so that's where I'm saying, now that makes me friggin' nervous.
There was one case.
You don't have the mic, they can't hear you. Send it to me on LinkedIn. I would love to know more. All right, I see someone with a talking stick.
Yeah, so just zooming out on the last few questions, as far as the output from a LLM, it's like what is your like overall approach to evaluating the output, and how deep do you actually dive into like a single complicated document to verify that the output is legitimate and not having any important gaps missing in your information?
Yeah, well, so it's a great question. So a lot of times with litigation, you're dealing with a focused set of issues. And a lot of times, I'm spending a lot of time going back and forth on it because the next step in litigation is arguing with a judge. And anytime you fill out a brief, the other side's going to say, let me tell you why Josh is full of shit, or whatever your name is. It's probably not Josh. Most people aren't named Josh. But I'll go pretty deep with it, and I also have found a lot of times it's good to challenge it. Now, in terms of the nature of language models, what did they get trained on? Internet data. What's internet data? People communicating. A lot of times, if you've ever seen a discussion thread about something, it starts off saying, bananas used to be tomatoes. And someone goes, that's bullshit. That's not true. And someone says, well, it's kind of true, or whatever. And so in the iteration of it, eventually you get more to the truth. So what I found is with language models, a lot of times you have to push back on it. So if you want to test the theories and stuff, like you really got to push in on it, but then you can get a more complete perspective on it. Does that answer your question or not so much?
It does.
Can you have the talking stick again?
It does for the most part. Like my concern is like it'll like say like you have a chain of prompts that you had, and it's not just that a slight change in the prompt can alter the output, but from what I understand, some language models will actually use the prompts or the output that it answered in previous prompts kind of as like a fact if you keep the thread going. So I'm talking about situations like that, and in a more general sense, do you compare multiple models for each thing, or do you make small changes to the prompt and then compare those outputs, things like that?
Yeah, so I will argue it back and forth, just horseshoes and hand grenades. I might have 10 separate threads on one topic to try to attack it from different angles. And I might then, like what I'd really usually do is start off with ChatGPT, argue it the 9 ways of Sunday, then go to Grok and say, hey Grok, what do you think? And present it that way. So it's a completely different model that hasn't inherited any of the back and forth and prejudices that I'd had before. Yeah. All right, you have the talking stick.
Yes, okay. I have a friend who's a trademark attorney, and he asked me if there's what he'd like to do is to be able to know when some trademark filing or response is due. And the trademark office has an application called TSDR, which is Trademark Status Document Retrieval. And he was able to get an API for that, and he's wondering if he can take that API and plug it into an AI program to let him know when a renewal is due or when a response is due and that type of thing, to automate that process.
Yeah, and I will say, so I do freelance work, I build stuff, I run a shop. So I literally could do that, but in general, people can do that. And what you're talking about is typically taking, so like an API is more of a, I'm gonna just call it traditional web product versus language models. So what a lot of folks can do now is basically, so in the situation you're describing, you probably could just have it be triggered by the API. You might not even need a language model. But like one of the things that is interesting is you can also have the language model read the thing. So if I'm saying, watch this case, and if you see a docket entry, let me know. Instead of just saying, let me know, it's pull the document, read it, summarize it, and send me the summary. You can add sort of the think about it before you notify me as well.
So let me add to that. You can also use a model context protocol. So you can register that API as a tool that the LLM will call. So your client calls the LLM. You say, I got this tool. I know how to call this facility over here to get that information. And then the LLM will call your client back and say, hey, run that API and then give me the results back. So you can integrate it into your workflow. And there's tools like N8N that can automate a lot of this, so you can do it yourself pretty quickly. And a lot of the world is transitioning to where most of these APIs that are commonly used become tools that LLMs can use in prosecuting a workflow you've asked them to do.
And I was thinking, like Josh was saying, that it might not necessarily need a LLM to do this. I've heard of something called Microsoft Automation. I'm assuming you could take that API and plug it into just something like that.
And I'll just give you a real easy example of technology that's existed for a very long time at this point. You could run a cron or a system timer and just say, I have this little Python script. Go hit this API. What happened? If this, then that. And they're computationally very inexpensive. Very easy to run.
Okay. And then I imagine he could say, I want at least a 2-week notification before something is due, or whatever he could put in there.
Yeah, I mean, I'll give you an example of how we're using cron/system timer right now. We've got some clients that we're doing marketing automation for. It goes and it reads the email box. And every hour, it looks back 2 hours, so this way we've got the gap covered, and it looks at the emails and says, okay, read the emails, and based off of what these emails are, if someone paid, then mark it paid. If someone has a question, send it to customer service, those sort of workflows. So there's a lot of workflows that can be automated with what I would consider traditional web computing that you don't need these advanced models for. And one of the things too, just sort of going back to like the local model versus using an API, on the local model level, you can get a lot of functionality without having a very computationally expensive model running because it's doing relatively simple stuff. Like one of the industries that got sort of just destroyed by language models is natural language processing, which was just being able to read text and infer what it said.
Okay, thank you.
Oh, the talking stick is traveling. Okay.
Thank you. I have the conch now. So one question, but 3 thoughts just to establish the train of thought. So absolutely 100% what you described, revolutionary. The amount of work effort that's going to go into legal work is going to be obliterated by LLM. Second, I believe that 95% of lawyers in the long run will lose their jobs in other industries as well. Third, you're extremely intelligent, and this allows you to go back and forth with the LLM exactly as how you described. But what most people will need in the future, long run, 100 years, 50 years, whatever, is an agent. The question is, at what point, or what do you think needs to happen for the legal industry to buckle and allow an agent to litigate for you in real time?
Okay, so there are about 500,000 to 1 million attorneys in this country, I think. There's about 300 to 350 million people, which means if one attorney could handle all of the legal needs for one person, then they would need to serve 300 to 350 clients. So I would say most attorneys will likely remain employed. They will likely be doing more valuable work. Where I actually think the transition is sort of tying back to our good friend here. I think what we're going to be able to see is more people drafting contracts between each other. And then you could actually have the attorney serve as the arbitrator on it. So in a sense, we can sort of upgrade attorneys to adjudicators on private, it's alternative dispute resolution, sort of mediation. All of the legal framework we need for that is already here. In terms of having an agent litigate, they'll never allow that. Part of the problem right now is that not to sound overly conspiratorial, not that I mind, however, the legal industry has its own sort of protected class and group. If you're represented or you're an attorney, you get to work by a set of rules, and everyone else has to basically kneel to that. What's happening now is with language models and advanced computing, going back to your first thought, yes, thank you for saying I'm intelligent. That's great. Always
That wasn't the
appreciated.
first one,
Flattery
but yes.
will get you everywhere. However, language models have been phenomenally great about being able to reduce to the intelligence level of wherever the individual is. A part of the argument that I've been making with an asshole in New York, he's an attorney that thinks the fact that people are broke means they shouldn't have equal access to the law. I've been arguing on that point. He said, well, you have the right to make whatever argument you want. Now, what he doesn't know is I have a disabled daughter. Under his logic, she'd never have equality under the law. That's not how that, equality under the law means equality under the law. So I think what we're seeing with the proliferation of what I'd consider just generally more advanced computing is more and more folks, independent of their current intelligence level, are able to get treated more equally. Like, if we think about our legal system at a really big, there was another version of this presentation I was working on yesterday that was more about our civic opportunity and how we can participate. Right, we vote for lawmakers. We vote for judges. And if they get that wrong, the jury can nullify a finding. So we have the ability, one of the sort of unrealized opportunities now is we can actually, as citizens, make better laws, have more transparency and understanding about how everything's working, and really shift the system. And so the value of, I don't think attorneys are going to be able to gatekeep access to the legal system anymore. I think that's forever. The next 5 years.
Okay,
Yeah.
one last question. Who's?
Actually, it's more of a comment. On a practical basis, corporate America does not rely on their attorneys to draft from scratch legal documents in terms of contracts. No contract would ever get out of the attorney's office for any business. Legal departments are commonly known as the anti-business department. And that's what we call it in our office. We have 700 employees, 21 companies, and we would never be able to enter a contract. And we've had, unfortunately, the mistake of having 3 of our attorneys kill deals because we left it to them from top to bottom. Most businesses will go ahead and draft the business terms that they want. And they're adamant about it because that's good business. Attorneys are not businessmen. Never make that mistake. They are there to protect you. And so they're automatically very conservative in their approach. And they take the law verbatim. And so once you understand that, you send your attorney, here's my agreement. Tell me what I need to protect. I will then determine what we're going to apply legally. You're making your suggestions, and I'm going to tell you what we're going to risk, because that's what you do in business. You're taking a risk. And if you leave it to a AI system to now draft agreements, that's the problem you're going to run into.
Well, so attorneys are very risk adverse.
Yes.
And opportunity is where risk thrives. All right, so we're at time, Tim?
We are.
All right, thanks everybody.